Yes, sir.
And how long were you investigator within that unit?
5 years.
Prior to coming to law enforcement, what kind of education or law enforcement background do you have?
Prior to my time in the Sheriff's Office, I was in the United States Marine Corps. I was honorably discharged as a sergeant. After my time in the service, I went to the University of Florida, and I've got a degree in telecommunication and a minor in criminology.
And were you working on 10/23 of 2013, October 23rd, 2013?
Yes, sir.
Were you activated or called to respond to a situation in Deltona in which Yesenia Suarez and her children were missing?
Yes, sir.
Tell us what you did first upon being activated.
I responded to 317 Covent Garden, which was the house of the family.
And at that time, what was the status of the investigation?
That time, Yesenia and her children were unaccounted for.
Roughly what time of day was it on the 23rd?
That I responded?
Yes, sir.
Yes, sir. It would have been after 2 p.m.
When you responded to that location, what was your first action and what did you do from there?
I met with some other major case investigators. At the time, Sergeant Tillman was my supervisor. He gave me a brief rundown, and he gave me an assignment of what I needed to do.
And what exactly was that assignment?
I was to respond to our operations center and interview Louis Toledo.
Now, prior to your arrival at the operations center where you conducted that interview, had you met the defendant, Louis Toledo?
No, sir.
Okay. Had you been in the defendant's house at all?
No, sir.
Do you see the defendant, Louis Toledo, here in court today?
Yes, sir.
Could you point him out? Tell us what he's wearing, please.
He's at the defendant table over there. He's wearing a black suit, wears glasses, and a striped tie.
And did you conduct an interview with that individual on October 23rd, 2013?
Yes, sir, I did.
In fact, did you conduct numerous interviews with him over the next several days?
Yes, sir, I did.
By the time that you had returned to the operations center to prepare for your interview, had law enforcement secured a large knife from the neighborhood of the defendant?
Maybe. I'm not sure if that was done during my interview or afterwards.
Okay. Investigator Pagliari, I'm going to, Judge, may I approach?
You may.
I'll approach with what's been marked State's Exhibit 6E's and State's Exhibit 6E's. Can you review these items and tell me if you recognize them, please, sir?
I do.
And what do you recognize those items to be?
One item is a flash drive that contains the interview that I conducted with Louis Toledo on October 23rd, 2013. The other is a transcript of that interview.
Have you had an opportunity to review both the transcript and the recording contained within the flash drive?
Yes, sir.
And are they a fair and accurate representation of the interview that you conducted on that particular day?
Yes, sir.
Is the transcript a fair and accurate representation of what appears within the recording?
Yes, sir.
When was the last time that you reviewed these two items?
About 2 days ago.
Now talk with us a minute before, actually, Judge State moves 6 C's into evidence and takes next for
Well, we've had discussions on this issue. Who wants to? Okay. We've had several discussions on multiple issues regarding this, and the court's previous rulings will stand. The item will be admitted into evidence.
Sergeant Pagliari, talk to us a moment about what we're going to see in this interview. Give us a sense of the setting, the individuals involved in the interview, the style of the interview being conducted. Help us kind of get an understanding before we begin to watch it.
Okay. The interview took place at our operations center. Also present is Sergeant Sheps. The interview took place in a standard interview room. I sat on one side. You'll see me on camera. And Louis Toledo sat on the other side of me. There's a table. I think it's a circular table that's in between. Sergeant Sheps is off camera in a corner. I'd say that the room is not a small room, not a big room. It's probably an average-sized room. And the tone of the interview is very laid back.
What was the purpose in conducting the interview on this particular day?
I needed to find out, since Jacinia and Leah and Elijah were unaccounted for, as much information as I could as to their possible whereabouts.
Was it a confrontational interview?
No, sir.
Would you categorize it more as an information gathering session?
Yes, sir.
What time was the interview conducted? What time did it begin?
It began about 4:15 in the afternoon.
Okay, and how long was the interview roughly?
It was about 2 hours and 20 minutes, maybe 2.5 hours.
During the course of the interview, were there breaks?
Yes, sir.
Was the defendant given access to the bathroom?
Yes, sir, he was.
Was he given food and drink when he requested it?
Yes, sir.
Have portions of those breaks, bathroom breaks and food and water maintenance breaks, have they been removed from the interview for the sake of time?
Yes, sir.
So if you spent 30 minutes drinking a cup of water, that's not going to be on the interview, right?
Yes, sir.
The interview, when these breaks were taken, and you left the room, what did you do when you were leaving the room?
Meeting with other investigators.
For what purpose?
Information gathering.
In what way?
When I was talking to Lewis, I was, in a sense, detached from the outside world. So as information would come in, I would try to get with them, the other investigators, and see if there was anything else that might be useful in my interview.
So when you're conducting the interview, you don't have like an earplug in, you're not listening to other things going on?
No, sir, I do not.
Okay. You're only paying attention to what's in the room, right?
Yes, sir.
Judge, at this point, state would move to publish States 111. We have transcripts for the jurors' review.
Okay, ladies and gentlemen, before this item is displayed, I have a few instructions for you, okay? You're about to hear recorded conversations. These recorded conversations are proper evidence, and you may consider them just as any other evidence. You're also being furnished transcripts of the recorded conversations. The recordings are the evidence, and the transcripts are provided to you only as a guide to help you follow as you listen to the recordings. The transcripts are not evidence of what was actually said or who said it. If you notice any difference between what you hear in the recordings and what you read in the transcript, you must rely on what you hear, not what you read. You're also about to hear or watch a recorded interview that contains opinions and statements by law enforcement officers to the defendant. These opinions and statements are pertinent only to explain the reactions and the responses they elicit. You are not to consider these opinions and statements by the police as true, but only to establish the context of the defendant's reactions and responses. Now, the court instructs you that the recordings have been edited to eliminate irrelevant portions that would not add to your understanding of the case. The fact that the recordings have been edited should not concern you in any way and must not impact the way you view or listen to and consider this evidence. I do want to point something out for you. The transcripts is not evidence. As such, they will not be in the back room when you get to deliberate. They're only used as an aid for you to listen. What you hear is the evidence, not the transcript itself, okay? You may proceed.
Thank you, Your Honor.
Counsel, you satisfied with the instructions? Okay.
Your Honor, we have a stack of transcripts down.
Can we get Deputy Taraborelli, can you hand out the transcripts to the jurors, please? Another rule is don't read ahead. You must read as you hear the recording, so don't get ahead, okay? Because the recording is the evidence you're going to be considering, I'm going to ask you to do this. If all of you can hear it, fine, no need to do anything. If you think it's too quiet, somebody go like this. So I know that you need the volume raised up. If you think it's too loud, somebody go like this. And let me know that. Yeah, we actually need one for there's one there. I'll take one, yeah. You may proceed.
Judge, could I have access to the screens?
Is everything set up over there?
Yeah, we're trying to figure out what I did with, How old are you now?
Huh?
How old are you now?
I'll be 32 in December.
32? Okay. December. My name is Investigator Pagliari. Okay, I work for the Lewis County Sheriff's Office. And I want to talk to you today about some missing people, okay? Our case number for it, it's 13-29517. From what I know of you, you're Louis Toledo?
Correct.
Okay. And I have your date of birth as December 19th? Okay, of 1981?
Correct.
All right. Do you live at the house 317 Covent Gardens?
Yes, sir.
Okay, that's in Deltona. And what's your phone number?
321-696-5859.
Okay. And who's your provider for that?
Sprint.
Sprint. Have you had them for a while?
Yes, me and my wife had them for a couple years now.
Okay. Or is the account under your account, or is it
It's my wife's.
your wife's account? You said 321
696
696
5859.
5859. Okay. I guess I want to lay it out there and tell you this, that this is a totally voluntary type thing for you, okay? I'm not going to talk anything about what happened in Seminole County. I have nothing to do with that. This is strictly a missing persons investigation. If you don't want to talk to me, you're free to go. I will take you back to the jail, and then the process will begin wherever Seminole County has on you. I want to talk to you. I need your help on this case, okay? Your wife is missing. And the two children are missing. Are they your children or her children?
They're my kids, because I
Okay.
raised them, but not biologically.
Okay.
I consider them my kids.
How long have you and your wife been together?
Almost 5 years.
5 years. Okay. And you've lived in Deltona the whole time?
No. We first moved in together in Maitland.
Bless you.
Excuse me. We first moved together in Maitland back in, I think, 09.
Okay.
And then we moved down to, excuse me, we moved down to the townhome. And right before the Trayvon shooting, we moved out of the townhome.
Wow.
And we bought the house. We got married in 2011.
Okay.
January 1st, 11.
Wow, that's pretty cool.
Yeah. And we got a house, and we've been there since.
Okay.
We kept the kids at Bentley Elementary because the townhome is still under her. It belongs to her uncle.
Okay.
So we kept them there because A+ schools in Volusia County, some Volusia County schools are not that good.
Okay.
I mean, as far as the elementary schools we're going right now,
Okay.
and the kids loved it there. And that was it. We've been there since.
Okay. So the kids still go to Bentley,
Yes, correct.
and that's in Seminole County?
Yes.
Okay. I'm not real familiar with, is it in Lake Mary,
So it's
Sanford?
across the street from the apartments, from the townhomes.
Okay.
It's where Kohl's is.
Is that Seminole Town Mall area?
Yes.
Okay.
Yeah, it's like right behind Kohl's.
Okay.
It's right across the street from Derby Park.
Okay. Now, I have the spelling of your wife's name. Her first name is
Yesenia.
Yesenia,
Yessenia.
Enia. Middle name was,
Yvette. Ivette.
okay, and then Suarez.
Suarez.
Okay. But your last name is different, but you guys are married. How does that work?
Because we never changed it over because of the school. We didn't want to have to go through the whole, FAFSA thing and all of that. So we just left it how it was until she finished school, and then we would switch the name when we had a chance.
Oh, okay. That makes sense.
It didn't mean anything to have the name changed over fast.
Okay. The two children I have, is it Michael?
Michael, Michael, and the middle name is Elijah, and
Okay.
his last name is Otto.
OTTO? Okay, let me just make sure, because what we did is we put out a teletype, because again, we don't know where they are, so we want to make sure that anyone who comes across them obviously gets in touch with us. So we went over the spelling of your wife's name, her date of birth. Do you know it off the top of your head?
Yes.
What's that?
It is 8/17/85.
Okay. And then we talked about Michael Otto.
It's 8/19/05.
Okay. And then his sister is
Talia Otto.
Dahlia Otto?
Yvette Otto. Yes.
Okay.
She has the same middle name as her mother.
Oh, okay. And her date of birth, do you know that?
Yes, it is October 8th, 2004.
Okay. All right, just making sure we had that correct, because again, I don't want to put bad information out, so it's obviously very paramount that we're putting out the right stuff. So I do appreciate you verifying that stuff for us. I could get into what happened today and the last time you saw him and stuff like that, but I really prefer to kind of understand more of the family dynamic. Is it okay if we talk about that?
Yeah, we can.
Okay, great. So you guys met 5 years ago,
Yes.
and you met in Orlando, Seminole County, Volusia?
We had met in Orlando. Her sister, which is Emily, I knew her as Nani. She used to date Gio and over and stay over with him at nights. And then they also had another cousin, which is lesbian. And me and her used to always hang out because, we were just cool. She was a lesbian, but she was like one of those stud guys,
Sure.
And she was showing me pictures, and she showed me pictures of her one day, and she was like, this is my other cousin. And I was like, wow, she's fine, she's beautiful. Hooked me up, and then her sister.
All right, back on the record. I'm seriously concerned that seemingly you all have agreements that don't materialize. I did not anticipate having to send the jury out in the middle of this because I thought you had received a copy of exactly what the jury would hear. Now we have an objection. And I'm not sure what we can do about it at this point in time other than hear you, see what the objection is.
Judge, for the purposes of the record, Mr. Dean and I got together with Mr. Johnson and Vicki Schwartz, a woman on my staff, and we went over the transcript and the recording. After the trial started,
Tell me how this
some
was
point.
done.
we
I'm
went, we went through the transcript and took out everything, and the recording, and took out everything that we believed to be objectionable in any way. We
You
then
did that on your own?
On our own. And then we provided it over to defense and asked them to get with us about anything else that they wanted to be taken out. And we went through each of their notes line by line, sitting in the jury room adjacent to this courtroom. And we went through it. Mr. Johnson, Ms. Schwartz, and I made notes about what we were going to take out. We came to agreements on the language that we wanted in. The objected to portion here, I believe, is about his wife's sister, and that she was naked in his home, and something about a naked ass was the I don't recall agreeing to anything about a cousin who's a lesbian, and I just don't recall agreeing to that. I've asked Ms. Schwartz to go back and get our copies of the transcripts that have my notes on them and her notes on them as we went through this proceeding with Mr. Dean as to which provisions would be stricken and which provisions we had agreed upon.
But was it an instance where somebody said, okay, strike out lines 10 to 15?
Yes, sir. That's what we did. We went through the transcript and we said the objected phrases are lines 10 through 15. This is the language. And we came to an agreement either way on everything that was supposed to be stricken. The things that I would be willing to take out with no fight, and the things that he'd be willing to live with no fight. There were things that he asked me for that I said no, and he said, okay, I'm not going to make a big deal of it then. That's not the end of the world. There were things that he asked me for, and I gave him without making a big deal of it. Because...
How about this transcript? When was it given to the defense, this particular one?
Well, the final transcript that was provided in court this morning was just finished by my staff last night. That's the problem with going through the trial and the defense still making objections. I mean, for instance, we haven't even talked about the recording that will be played tomorrow. They're still making fine-tuning notes. They still haven't told us what they believe to be objectionable. We're going to have to work like crazy to get it done tonight, to be played tomorrow. And this particular transcript of the 23rd and the 24th was just finalized last night. I haven't had a chance to watch them all the way through because it's about 6.5 hours of video, and I was in court last night working last night until about 8 o'clock. So I have not reviewed everything. My staff has, and they've assured me that the things that Mr. Dean requested and we agreed upon were taken both out of the recording and out of the transcript.
Okay, Mr. Dean, here's the problem. We can't do this way right now. Either I'm going to give the jury 3 hours off and we go through this thing line by line. Well, you tell me this, but then 11 pages into it, we already have... Okay, that's what I said. Do I need to give the jury 3 hours off so you can read it all to make sure that it's unobjected to? Do you want to read the whole thing? How many other surprises are coming down the pipe is what I need to know. I don't want to have the jury come in and out because we missed something or there was a misunderstanding.
And Judge, just for the purpose of the record, I now have my transcript here with the notes from our meeting, and I have absolutely no notes about taking anything out on page 11. If he requested it, we certainly didn't, he didn't make it seem like a big deal. It's one of those situations where we didn't take it out.
Do you need time to go over the transcript? I will give it to you.
I would invite them to do that so that we can play this thing through and that there's no problems. If there's something that they want to fix, then we have time to fix it before the jury hears it.
You take the jury down to the other room, tell them it's going to be at least an hour.
Yes, sir.
Okay? All right, we'll be in recess for 1 hour.
All right.
All right, bring the jury in.
Now the jury's been present for 14 years.
Thanks. Everyone, please be seated. All right, ladies and gentlemen, from time to time, things occur that is beyond anyone's control. And one of those things occurred this morning. I would hate to keep you around the courthouse for an indefinite period of time, having you wondering what's going on. But we have some technical issues that we have to go over, some things that we thought we had clarified, but there appears to have been a misunderstanding among all of us. So what I'd like to do is this. Instead of having you here sit for 2-3 hours, I'm going to just go ahead and send you home and give you the rest of the day to do whatever you like. You're welcome. I prefer that you don't go to work. I prefer you go home. But if you must go to work, please be sure that you tell whoever you work with not to say anything to you about the case, not to discuss any of the aspects that have been coming out in the media or the newspaper or whatnot. Don't talk with anyone about the case. Don't do any research. Don't assume anything about the fact that we're having to take a break. I warned you about that when we did jury selections, that there are some specific instances of time where we just have these breaks that we have to take and do some other things outside your presence so we can make this process go a little bit more smoothly. So this is just a minor bump on the road. I'll release you. We will try it again tomorrow at 9 a.m. I'll come in a little bit early so we can get started right on time, just like you've been doing. Keep in mind, I want to just double emphasize, don't research the case, don't talk to anyone, including each other about the case, and please don't speculate, okay? Yes? I'm sorry? Yes, Friday schedule as a day off. So we're going to be working today, just to try to plan the rest of the trial. Actually, we're talking into next week already, just to give you an idea of when things might happen next week. Hopefully by tomorrow afternoon, I can give you an idea where we are and what's expected of you. Okay? Any other questions? All right. So if you want to go to work, but don't let anybody tell you anything. Okay? Okay, the jury is out. Do you need Mr. Toledo to do the things we need to do, or so he can be excused? All right, so go ahead and remove Mr. Toledo from the courtroom. For those of you who want to remain in the courtroom, all we're going to do is go over some transcripts to make sure that the parties agree on what the jurors should hear as part of the trial. You want to keep them? All right. I'm not staying. But you said at 26, there may be some argument about that. Is that the 26? Is that the only thing that I need to rule on? Okay, then go ahead and have him take a seat. We'll take care of it right now. Folks, you can sit down if you like or leave as you please. Witness, step down.
Aye, sir.
Jeff, what page are we on for the 26th?
I do want to put on the record that we got as far as page 11 on the transcript of the 23rd, and that's when we stopped.
Yes, sir. The recording was about 6 minutes and change.
All right. So, I need a copy. You,
I don't know that I have a copy.
of the 26? I can come down. I'll go, come down.
So starting at page 2.
Okay, for
Lines-
the record, this is a transcript of Luis Toledo's interview from October 26th.
I'm looking at the original transcript. Your pages might be different.
Well,
Can't hear us? Can we go there?
well, it might help if we all work off of the same transcript. So which
agree.
one should we use?
Let's use ours from the state because it's been changed.
Okay, I'm going to initial it. This is the one that become the one that has my initial on page 1. Yeah.
On this transcript, it starts at page 3. And the lead up to it is page 2. Where also Pagliaro is talking. He says, my understanding is talk to you again every day since Wednesday since this began. Did you notify one of the guards and notify someone at the jail you wish to talk to her? Mr. Toledo says, I told him to tell you to check the gator pit. And then there's a whole, first thing they do is give him the example one, and then, where are these gator pits you're talking about? I don't know.
So we're speaking about page 5,
Yes.
line
Starting at
14, so, okay.
where are these gator pits you're talking about? I don't know. Would you be able to take us there? Maybe, I don't know. They were in Sanford. Do you remember how far into Sanford or off what major street? And we're trying to figure out where that is. And we're still talking about where that is on page 6. And then the investigator asked him on line 12, so a gator pit close to I-4. He was, I don't know, I've never seen it. I thought he could be there before, he never could be there. He is, I believe, the part-time guy. In my opinion, he offered to take me. I told him I don't go in water. If I can't see my feet, I don't go in the woods. How did this conversation come up? And then there's a discussion about the bodies of the people maybe greater fit.
Okay, so what is the objection to the,
We object that it's not relevant. We object that even if it is, it has so much prejudicial value that it outweighs the appropriate value. The bodies have never been found. So put out something good. It's so prejudicial. It has no basis. It's the only time it's ever talked about. It's so prejudicial.
okay, so if I understand it correctly, your client called the jail and asked for law enforcement to come? And this discussion here talks about where they might be able to find the bodies.
There's no place on that. There's not
This is Florida. Every but he's specific as to areas.
Not really. I was born in San
What says the state?
The question about relevance is that the defendant has called law enforcement to him to explain in the series of conversations he has that Tyshawn Jackson has disposed of the bodies in cooperation with him, or however that worked out, that Tyshawn has disposed of the bodies in this location in Gator Pit over in Tampa. And he gives his best effort to describe where they are. I believe it's irrelevant because it clearly relates to the subject that we're discussing. As far as prejudicial, I don't see how it's prejudicial to the defendant. If we're talking about the inflammatory nature of the statement that somehow these children were fed to gators, then they were fed by Tyshawn to the gators. Rather, well, that's what he's talking about, because Tyshawn put them into the gator pit. And, yeah, and so I don't see what prejudicial effect that has to this particular defendant. When he's telling the police that this is what Tyshawn did, you ought to check there, I'm trying to help you. I'm trying to help law enforcement find these kids. And that's the way that this conversation is couched.
I want to read it whenever you get done there.
There's a reference. I'm just trying to find it. So it started with 3. A while back, I remember talking about taking the jail away to just whatever. There's no.
Okay, the transcript begins in mid-sentence with a question, water. Is that correct?
Correct. They're asking if you want to drink of water. You see the video, you understand.
Okay. Is this the same day that he goes into the bathroom? Is that also part of what we need to, is that agreed upon?
I think we need to address it.
All right. What exact, I mean, obviously the issue in this case is finding these folks. Do you think that by him offering a statement to check a certain place, in this case, gator pits, that somehow is prejudicial to him? Although he's suggesting someone else might have done the tossing of the bodies in the gator pits. Okay. I think it's relevant, and I think it's not so prejudicial to your clients. I would allow it. Now, you want to go on to the latter part? Do you need to play it?
I do. It's about a 10-minute recording.
Then let's do it.
Okay. Judge, we're waiting on the hard drive. Investigator Seymour took it back to start working on some changes on the tape that we just discussed. So he'll be here in just a moment.
Okay. While we're waiting, Mr. Nielsen was not in the back when we had a discussion about scheduling. I'm going to spend the rest of the day doing a rough draft of the jury instructions, and I'll email that to you today, both sides, so you can start looking at them and mulling them over and have them over the weekend. But I need to get an idea of roughly where we are in terms of giving the case to the jury. Today is the, I think is the 18th, I'm not really sure. Today's the 18th, yeah. And the state back in chambers indicated possibly coming close to resting on the 24th, which would be next Tuesday.
With this hiccup, it may be Wednesday, but we're thinking Tuesday or Wednesday, depending upon how things play out.
Okay. And your best guess of the estimated length of your presentation, if you can just give me just an estimate. I'm not going to hold you to it. Just that would give us a very big gap. If the state were to rest on the 24th, that's a Tuesday.
Well, we have other
You think you have enough witnesses to fill 3 days? If you don't mind, because a couple of things. Number one, I have to anticipate when jury deliberations will begin. I have to make arrangements for juror sequestration. I'd like to get the sheriff folks plenty of time because obviously they have to prepare for that. Number one. Number two is I'm looking at the calendar and we're getting towards the latter part of the month. And should there be a penalty phase, that may push us into the first full week of November. Yeah, please give it a serious talk, and I don't know about your witness that's unavailable, if we can make them available by other means, or if you need to let me know, we can have a closed circuit, then we have that capability to. So let me know, okay? All right. Before everyone leaves, I would like to get everyone's email. So
Yes,
I'll
sir.
send the jury instruction to everybody. So
Yes,
that
sir.
we.
Okay, Judge, I'm prepared to play it for the ending of the 26th, the stuff that's off the transcript.
This is the 26th.
Yes, sir.
Okay, very well. And this is the end, correct?
This is the last about 11 minutes of the interview. All of the action in the room has concluded, and I think it's described in the transcript as hearing bangs and screams.
Can I see the transcript, the
Yes,
one
sir.
that I signed?
Yes, sir.
Well, I want to make sure. So my dad said there's nothing wrong with wearing suspenders on a belt. Make sure your trousers don't come off. All right, go ahead.
Yes, sir.
Turn the volume up.
But I need you. Go. Break it. I got it. On the way. Everything okay out there? I locked myself in. Maybe in my kitchen.
Okay? Is that the end?
Yes, sir.
All right. I'm sure the court reporter wasn't able to take down much of it. Sounds in the background, it sounds hectic and muffled and quiet, but, okay, tell me anything else you want to tell me before I make a ruling.
I'm not real sure what we're addressing at this point, whether we're just talking about the portion of the recording or if we're making a full argument to the
Well-
suicide as well.
Let's hear from, is it Mr. Dean? Is it the attempted suicide testimony that might come from a witness? Is it this recording that you object to? Is it both?
That's the first time that we have
Sure, absolutely. Do you want to go till 1:30? I have, go ahead. Yes, sir, you can use the jury room. Leave him in here, when he's in the record. Yes, sir.
Judge, I have two objections about it. One was raised in the pre-trial motion, and that the state had to make a predicate for this. This is not just something that comes in. I believe this is relevant. If there's a claim of relevancy, it has to be that it's on evidence of conscience or guilt. This side goes in with all the other ways that someone would express conscience or guilt to avoid prosecution. So it's actually in the law, the same as life. It's actually the exact same thing as life. The court believes that Mr. Toledo is committing essentially suicide based on the fact that he was going to avoid prosecution. That's the only way this is going. With the case law that I read. The case law that I read, and the case law that cites from this room is Penelon versus State, which is at 594-292.
Hold on. What was the name of the case?
Penelon,
Yeah.
Yes, so that case, in the body of the case, it says the court has noted that right alone, there's no more decision to do in it, saying that suicide.
Give me the site again.
594, 292.
Give me 1 second. Do you know which head note is the,
I would say that if you look at the West Hall version,
I am,
it's on page 295 in the body of the case.
295,
Which is about a third way down in the case.
starting with Placencia? That's where the page begins, in the site?
Go down to line, break in paragraph, plus the
Yes. Now, this dates back to a time when there used to be a flight instruction, which there no longer is a flight instruction.
I'm talking about the predicate for it, so the other two cases that I cited before, I think I gave you before in the pre-trial motion, and I was citing again. One is Ken Waiver.
Just give me the site.
Yes, sir, it's at 926, Southern Second, 1118.
Okay. Okay.
Now, that case is about suicide. There's a 5. I'm sorry, not you had no 11, 12, 15.
Mm-hmm.
They're grouped together. And that case says that it says the attempted suicide of a person after his suspect of a crime is proven beyond a reasonable doubt may be considered by the jury an indication of desire to evade prosecution. And one of the series of circumstances on which guilt may be inferred, you may find the suicide considered with other factors such as innocence. Evidence of attempted suicide is sufficient to be attached to when jury questions once they're admitted. Evidence of attempt at suicide is inadmissible as evidence of competent guilt because at the time the defendant attempted suicide was guilty of the charges. This is the issue in this case addresses, which is the proof of consequence of guilt. There has to be some measure of proof towards that. It has to be not a reasonable doubt that these instructions are lumped in with the flight instruction, which is why I showed you that it's all the same according to the law that I've read. So what I'm saying to you is that if flight, if the fact of flight neither proves guilt nor innocence, neither does the fact of suicide. And the attempted suicide in itself is not it's relevant. To be relevant, it has to be shown by not a reasonable doubt that there's a consequence of guilt and you defend to obey prosecution. That's the only way it becomes relevant. You know showing that. Only showing they try to commit suicide. That's really out. That has no context. If you know testimony about it, the only thing that will happen is that when the statement is played, that's when it will become known and that's what it will be. There won't be any testimony that he was, that he gave the prosecution. He's allowed to feel grief if he did. If it's just as consistent with any other theory, it's not proof of consequence. Showing it that would be the case before it's being committed. Our objection is that there has been no predicate to show consequence of guilt prior to the event being admitted into evidence.
Okay, State.
I want to make sure that you said you had a second issue. Does that relate to the video?
Yes.
Okay. As far as it relates to the suicide issue, Judge, the defense is correct. There has to be a nexus between the conduct of attempting to commit suicide and the attempt to avoid prosecution. And so let me just briefly lay a record to tell us where we are prior to the interview on the 26th. Prior to the interview on the 26th, the portion that we just watched, the defendant has had 3 conversations with law enforcement where he has gone from denying anything occurred at all and saying simply that his wife left him in the middle of the night and she can't be found. On the 23rd, that was his statement. On the 24th, he's been confronted with his guilt or evidence of his guilt, items that he's disposed of around the community. His statement immediately changes from, I don't know what you're talking about, she left, to, you're right, I killed my wife, Tyshawn Jackson killed the neighbors. And I'm paraphrasing for speed, but he
Tyshawn Jackson killed the children.
Right, excuse me, I'm sorry, Tyshawn Jackson killed the children. And then Tyshawn Jackson was the one responsible for the disposal of all 3 bodies. I don't know where they are. It's essentially the defendant's position, and he holds that position on the 24th, the 25th, and then on the 26th. You read a portion of the transcript from the 26th where he calls investigators to the jail to talk with him in an effort to reveal information about where these bodies may have been hidden by Tyshawn Jackson. And that's the portion of the interview that precedes this attempt to commit suicide. As you recall, during this 45 or so minute interview, the defendant asks to use the bathroom on 3 separate occasions. He immediately comes in complaining of his stomach bothering him. He asks to use the bathroom, and during his second trip to the bathroom, which occurs somewhere around 25 minutes or so into the recording, he tells Sergeant Sheps to come with him. And what had happened on a previous trip is that 2 investigators escorted him to the bathroom. On the second trip, as he's leaving the room, he can be heard saying to Sergeant Sheps, "Just you." And Sergeant Sheps goes with him. What Sergeant Sheps will testify to when he comes to trial is, and he's already said it in his deposition, and it's been reported several times by several officers, is that essentially when he gets to the bathroom with the defendant, the door remains open so that the defendant may be monitored. The defendant is using the restroom facilities, And there is a conversation that occurs between Sheps and the defendant, wherein the defendant tells Sheps, are you recording this? Sheps says yes. The defendant says, toss it, meaning toss your recorder. And so Sheps tosses his recorder and turns it off. The recorder breaks, and so that the interaction can't be recorded in any way. The conversation that follows is essentially that the defendant is asked more questions about where the bodies are, and during this moment that he's talking with Investigator Sergeant Sheps, he tells Sergeant Sheps, I'll never tell you where the bodies are, which is materially different than what he's maintained to this point in the case, where he blames Tyshawn Jackson for the murder of the children and the disposal of all 3 bodies. And so he changes his statement on the 26th for purposes known only to him, but it's a material change in statement. When they get back to the interview room, Sergeant Sheps then tries to lay as much of a record into the recording about the conversation that occurred in the bathroom, at which point the defendant then asks to use the restroom again. This is the 3rd trip to the restroom. He's excused from the room and taken from the interview room. You've seen the video. As he's taken around the corner, the audio in the video room is able to record several of the events. And just to kind of lay the record, he's excused from the interview room, and within seconds you hear the bathroom door close and you hear glass breaking, which is, I believe, the defendant breaking the mirror in the bathroom at the sheriff's office. You then hear someone banging or kicking on the door, which is one of or more than one of the 3 investigators that are involved on this particular occasion. Investigator Pagliari, Sergeant Sheps, and Investigator Brian Ford are attempting to kick the door open to get access back to the defendant. You then hear a long silence with running up and down the hallway, and then in a few minutes you hear a louder banging, which is where the investigators have gotten a battering ram and a taser, and they're breaking the door down in the Volusia County Sheriff's Office in an effort to gain access to the bathroom where defendant has concealed himself. They're eventually able to put a hole in the bathroom door, and just enough to get the taser in, and are able to taser the defendant, at which point he is dragged out of the bathroom onto the floor in the hallway, and you can begin to start hearing comments that occur between the investigator and the defendant. And I made some notes as we went that there is some iteration of tell me where they are and let me die. That the investigators are yelling at the defendant, tell me where they are, tell me where they are, tell me where they are now. And the defendant is responding, let me die, let me die, let me die. And that's just what you can hear in the recording. The investigators may have additional details that they have shared previously or will share at trial. But this occurred on at least 4 times during the recording that I was able to hear as it played here in open court. And so what the state has to show is that there's a relevant connection between the event itself and consciousness of guilt. And I would direct you to the Sloan case. It's 104 Southern 3rd, 1271. And I'd turn your attention to the middle of that case, but particularly if you look at the last 2 paragraphs, which are on 1274, what the court talks about here after citing the Penalver case and talking about the change in the law and the necessity to put forth this predicate, they then go on to say that where the defendant in Sloan actually attempted to commit suicide and then tried to flee from the state, because he was aware of the initiation of an investigation prior to those attempts. What happened is it was a sex case, and the mother of the victim told the defendant that the cops were looking at him. And so he then attempts to commit suicide, flees from the state. The court said that those 2 actions, both the attempt to commit suicide and the flight from the state, are relevant to show that he was attempting to avoid prosecution and was attempting to avoid being held accountable for his crimes. And I think that that's akin to the situation that we have here, where the defendant has already confessed to at least 1 murder, and then his statement materially changes on the 26th as it relates potentially to the other 2 murders and certainly to the location of the bodies which is apparently within his realm of knowledge. And so here I think we have sufficient facts to show a nexus between his consciousness of guilt and his attempt to commit suicide. And the state would ask you to allow presentation not only of the evidence of the suicide attempt, but also the recording, because I think it clearly demonstrates the order by which things occurred on that particular day.
Okay, Mr. Dean.
In this case, the opposite behavior has occurred with Toledo. From the very beginning of all these interviews, countless hours of interviews, he's cooperating, he stayed as long as anybody was having him talk. Basically, he stayed and talked, he's cooperated. He's evidence, his willingness to cooperate no matter what interpretation he was doing now. And the thing about it is that the suicide consciousness of guilt can't be manufactured to the police. So when the police are saying, tell me now, they're reacting to what he's already done. That's not evidence of consciousness of guilt by Mr. Toledo. That's evidence that the police are asking him questions in a situation in which he's attempted to commit suicide. Mr. Toledo would have had to evidence the consciousness of guilt prior to that. He hasn't done it. He's cooperated all the way through. Even in the evidence that he's asked the court to keep out, he's summoned the police to come and tell them more stuff. He is not evidence of consciousness of guilt. His suicide has not been demonstrated to do that. All that was recounted to you now was what happened with the suicide, not evidence that he had a consciousness of guilt. The court says the state must deduce evidence that the reason for, and this I'm reading Henley, that says flight was to avoid being held accountable for the crime. It's not. He hasn't done anything like that. It's not that he committed suicide, that he tried to commit suicide, that he is trying to avoid being held accountable for the crime. The fact that the police are screaming questions at him at that point doesn't make it so that he's the one that is trying to evade prosecution because they're asking him questions at that point. That doesn't turn it into that situation. He would have had to have done that prior to the attempt to suicide. In one case, that's what the guy did. He heard about it and ran. That's essentially that. So what we're saying is that they haven't made the predicate. There's no evidence that allows him to do that. He did it for any other reason other than to avoid prosecution. And the predicate can't be made. It can't be made based on the event that happened after he did it. The event already happened. He already attempted suicide. But what the police say after that on reacting to it, that's not the evidence that was intended.
Okay. As proffered, I believe the evidence is sufficient to establish a nexus between the ongoing investigation with the missing folks in this case and his consciousness of guilt. By the time that he made this attempt, he had made very incriminating statements, I think. And this is, I'm going from the proffer, by the way. I don't know what he's going to say. I'm assuming the proffer is accurate. But he indicated that he may have killed his own wife and then that someone else killed the children, I think, as it relates to his admission to killing the wife. And what preceded at least from what I read from the transcript of the 26, him trying to assist with information as to the locations of the bodies and indicating that they may be in some sort of a gator pit, clearly weighs in on my decision that he's basically getting cornered by law enforcement and is looking for a way out. And he did so by attempting suicide. So that'll be my ruling.
Thank you, sir.
Okay? All right, thank you. Anything else?
No, sir.
The other objection we have about the recording is
The actual recording that we've heard, yeah.
I'm asking the court, what people can hear when they say they can hear, I think is supposed to be interpretation. I don't know that it's all that clear. What you heard, and what I heard, or what Mr. Willman hear or want to say, is not all that clear. So I would ask the court to not allow anybody to add words. I don't know that any of that, other than the police yelling at each other, to get help, is all that clear. So what I'm asking is that, we don't substitute words for what they're thinking.
I have to say this much. The quality of the sound system in this courtroom is very, very good. Probably the best one I've ever heard of any courtroom. So you can make out words. I mean, you can hear things coming from the recording. Some of them I can't make out, but, I wear hearing aids, and I don't know what the jurors will be able to hear and not hear. In fact, I know that juror 26 probably will have a tough time making out anything that's coming out of the speakers, yet some of the other jurors might have an opportunity to hear the things that are claimed to have been said. At the end of the day, they're going to be told that what they hear is the evidence, not what you say is the evidence. Or nothing. It's going to be up to them to make up their own minds to see whether or not they want to hear it 100 times or 1,000 times until they hear the words that they think they need to hear. We'll be here for that. So I think each side is free to argue and point out to them to listen to it and encourage them to review the evidence to see whether or not things that are alleged are the things that are actually said. So I would be inclined to allow the recording.
Thank you, Your Honor.
As usual, we also have to
Right. Right, and we've had several pretrial discussions on that and extensive ruling on it. So over the objection, recording will be admitted.
Okay, thank you, Judge. We'll get to work on the rest of it.
All right, if you leave me your email address with Adrian, I will do the jury instructions when I come back from lunch. Email them to you before 5 o'clock today. Okay. All right. I got Nielsen's too? All right, good deal. All right, we will be adjourned till tomorrow morning at 8:30.
Johnson,